Hello, everyone, and welcome to the Jeffrey Epstein Show. I'm your host, Bobbycapucci, and this is Daily Drop number 284. We have some news out of Judge Preska's courtroom, and it looks like it is exactly as we expected. It's going to be a long process for these documents to be unsealed. Now, Preska already stated previously that she was going to do this in a rolling fashion, and she has now laid out the groundwork for the two sides and how things are going to proceed as far as documents being unsealed. Now, there are a lot of things that she had to take into account, right? The fact that some people are going to be named and they have to be made aware that they're going to be named, just a whole bunch of legal stuff. So it's going to take some time for this to happen. The article we're going to read tonight from Law and Crime will give us a better idea on just exactly what that process is going to be. Now, as you all know, I like to use Law and Crime whenever we can when it comes to this sort of legal type situation, considering that's what they do. This is what they report on. This is their bread and butter, and they have done good work here on the Epstein case. So let's jump into the article and see if Law and Crime can add a little bit of meat to the bone and put a little context in this for us. Judge reveals process for releasing more secret Jeffrey Epstein files. This is going to take a while. The author of this article is Colin Kalmbacher. A federal court in New York City determined the categories of people whose names will appear in the latest tranche of materials related to Jeffrey Epstein and how they will be able to object. The process is complicated and time-consuming. Yeah, unfortunately, just about anything that goes on in federal court especially is going to be time-consuming and complicated. And, like usual, I am not a lawyer, right? So I'm just muddling my way through this stuff just like you. And that's why, again, I use Law and Crime and not some other website where you just get a basic idea of what's going on. At least they give you a little bit of context here. And Colin is somebody who obviously knows what they're talking about. So it makes it a little easier to understand, right? So that's what we're going to try and do. But again, I most certainly am not a lawyer, and some of this stuff just makes your head spin and your eyes roll back in your head, right? Just all the legalese nonsense. U.S. District Judge for the Southern District of New York, Loretta Preska, outlined those categories in a 5-page order released Thursday afternoon. The names will include A. Persons who produced or answered discovery based upon the representation or understanding that the discovery would be subject to the protective order previously issued in this action. All right, so that sounds like whoever gave a discovery deposition and thought that it was going to be concealed under the protective order, they're going to be notified that their name is going to be released in these unsealed documents. B. Persons who are identified as having allegedly engaged in sexual acts with Virginia Roberts or other alleged victims or allegedly facilitated such acts. All right, so that portion is people who are having the finger pointed at them by Virginia or other survivors, naming them directly as people who took part in the crimes or who helped facilitate those crimes. So those people who are named in the documents that are going to be released must also be made aware that their names are mentioned and that they are in jeopardy of having their information put on blast. So they will be notified, and then they will be given, I think 2 weeks. I believe 2 weeks. I'm sure it'll tell us in this article. I believe they have 2 weeks to answer the charges or answer the fact that their information is involved in these documents that are being unsealed. C. Persons whose intimate, sexual, or private conduct is described in the sealed materials, So obviously anyone who talks about any intimate situation they were involved in regards to the Jeffrey Epstein criminal enterprise, those people will also be identified, and not identified, but they will be contacted, and they will be told that their names are going to be coming out as well. And if they object, then now is the time to do so. D. Persons who are alleged to have been victimized by Epstein and Ghislaine Maxwell. Again, same situation. If those names come up in documents that are going to be unsealed, then they must be contacted first, them and their lawyers, and told that their names are going to be brought up in these documents, and they'll have a chance to object to that. The slate of names is being sourced from filings made by attorney for both Roberts and Maxwell. Each side presumes that the people on their prospective lists are likely to suffer privacy, reputational, or other damage when and if their names are revealed in the Epstein files. So this is where it gets a bit confusing, right? So both sides are saying that certain names shouldn't be released without those people being told first, because they could suffer privacy, reputational, or other damages. Now, for me, I think the most interesting part is, and I guess for everybody probably, is what those names are, who those people are. And if they object to their names being revealed in these documents that get unsealed, then I'm sure that there will be some sort of process for the judge to decide if she is going to keep their names private with redactions, or if she will go through and just release the documents as is. I guess that will be up to Preska, and it will be at her discretion. I am not positive about that, but I believe that is how it works. Because the original parties, Roberts and Maxwell, did not agree on one or more non-parties to be included in the list, the court has resolved all such disagreements and shall issue to the original parties a court-approved non-parties list, which shall be sealed, the order notes, explaining that each non-party will be identified by his or her name, which correlates to a unique pseudonym identifier, i.e. Doe number 1, Doe number 2, and Doe number 3. So it looks like Virginia's lawyers and Maxwell's lawyers couldn't come to an agreement on one or more of the non-parties that should be included in the list, so the court stepped in and they have resolved those disagreements. And now the court is going to issue the original parties with the non-parties list. So again, this is confusing stuff, right? This is definitely the kind of situation where we have to stay on top of it, because it's a lot for those of us who are not lawyers to, manage to wade our way through, because there's just, a bunch going on here, right? So, but basically what is going on is the court had to step in because the lawyers couldn't come to an agreement, and now the court is going to facilitate the process. Preska plans to review several sealed filings at a time in order to facilitate the review on a rolling basis and in a manageable fashion. That will take stock of each name as it appears in the secret Epstein files. Well, that's not really new. We knew that Judge Preska planned on doing this on a rolling basis, that she planned on doing it in increments, right? Have one tranche of documents released, go through the next, make sure everything's legit, release that tranche, and that's the way she has said from the beginning that this was going to occur. But now, with the court having to facilitate all of this as well, it should get pretty interesting, and it's probably going to be a bit of a drawn-out process. But again, when it comes to the federal court system, I expected nothing less. The order notes how this will work in real time. For example, for Doe number 1, the court would review each sealed item that mentions Doe number 1 and would do the same for Does number 2, number 3, etc. This will allow the court more easily to manage and review any objections from non-parties. So again, remember, this doesn't mean that their names are going to be redacted and nobody's going to know who they are. They have a chance to object to their names being released in these documents. And then it will be up to Judge Preska ultimately to decide one way or the other. Roberts and Maxwell will be alerted via judicial minute order notifications that any given person stands to have their name revealed in any given set of documents. Both Roberts and Maxwell's attorneys will then be tasked with confidentially altering each of the people named in the materials. So, if somebody has to get their name redacted, the court will let the attorneys know so that they can take the steps that are needed to be taken to make sure that things remain as confidential as the protective order demands that they remain. Service shall be effected via first-class certified mail, return receipt requested, the order notes. After service, the party causing the service, so the party who is sending the mail, a certificate of service stating the date and method of service and identifying the non-party by his or her pseudonym identifier. So, obviously not by name, by pseudonym identifier. That's the key. It's about privacy here is what's going on. It's to make sure that people's privacy is respected in both areas, to make sure that people who are mentioned within these documents have their chance to object. And there is a good chance that a lot of these people will object, right? I mean, you would think. And then it moves on to the next step, where Preska ultimately will decide. Various timelines begin to toll once a named person is served notice of their presence in the Epstein files. Within 14 days of service of the non-party notice, a non-party identified by his or her pseudonym may submit to the court a request for excerpts of the sealed materials pertaining to him or her. The order notes given a named person 2 weeks from the date of service to request context about why they were included in the sealed materials. All right, so they have basically a month when they get notice that they're going to be mentioned in this. And then it gives them the 2 weeks from the date of the service to request context. So once they get served, once they get this information, they have that 2 weeks from the date that they are served to request all the information that's involved that has to do with them and why they were included in these sealed materials. Upon receiving the excerpts, those people will then be granted an additional 2-week period to file objections. All right, so that's a month, right? So that's how that's what it's going to be like. So I would guess that something like this will happen. We'll see a tranche of documents dumped 1 month, then we'll have a month or two off. A tranche dumped, a month or two off. A tranche dumped, a month or two off until there are none left. That is the way I think it's going to break. But again, I don't have any inside information. That's just speculation on my part. That's already 1 month from notice of being served that they're mentioned in the Epstein files to mount a case against the public ever knowing of their affiliation with the Epstein saga. So that's where it gets dicey, right? These people are going to have a chance to keep their names off the record. That cannot occur. I mean, there is no way that should ever occur at this point. I don't want to hear no redactions. I don't want none of that BS, none of it at all. Because at this point, if you're named in those documents, my friend, you should not have been associating with Jeffrey Epstein. And if you're close enough to be named in these documents, well, you were probably pretty close to Epstein and Maxwell. After filing their initial objection, there are 3 additional 7-day periods that allow 1. Attorneys for Roberts and Maxwell to object to that objection, 2, attorneys for the named people to file an opposition, and 3, attorneys for Roberts and Maxwell to file additional support for their opposition. So it becomes even more convoluted, right? That's why I said a month or 2 and then another dump. So you're looking at it could be another 3 weeks right there. So you're looking at about 2 months of time between each one of these tranches of information getting dumped. And that is after all of the legal wrangling. But again, folks, I told you, you have to set yourself up and be prepared for this to occur. This is a federal battle with high profile people and lawyers, and there's going to be a lot of wrangling. There's going to be a lot of dragging of the feet. These people are going to try and drag this out as long as possible. That's just what they do. Those multiple timelines already stake out at least 2 months worth of waiting for the next tranche of files related to Epstein's alleged global sex trafficking empire for the elite. But that's all essentially just the first step in the process. Per Judge Preska's order, after objections, responses, and replies have been submitted and any evidentiary hearing held, the court will enter a minute order setting the date and time it will decide in open court the objections lodged as to each set of motions. Well, that does sound like it could take a long time. I will say this. Preska has been pretty solid with keeping to a schedule here and keeping things moving in a forthright manner because she has really unclogged things here. So I would expect Preska not to take too long going over these documents after all of the objections have been turned in. Appearance by any of the parties or non-parties is optional. The court will determine whether each sealed item shall be 1, unsealed in its entirety, 2, unsealed in redacted form, or 3, kept under seal. Thereafter, the court will issue a notification of the next set of sealed items to be decided. So, again, look, let me just prepare you folks out there for the fact that some of this stuff might not end up breaking the way we want it to break, right? We have to expect that. We have to expect that these high-profile lawyers are going to catch some W's along the way. They're going to get some victories along the way. And there might be some pieces of this information that are not brought to light right away. But there's the appeals process. There are several other steps. It doesn't mean that it will never be brought to light. It just means that this time around, for whatever reason, Preska, the judge, has decided not to release it unredacted or to keep it sealed completely. So just prepare yourself for stuff like that to happen because it's going to. In other words, the names that will be revealed, if they are revealed at all, shouldn't be expected anytime soon. And for us here on the podcast, we knew that. We knew that we shouldn't expect more documents anytime soon. Preska has been very clear about how she's going to go about this, how these documents are going to roll out, and how she plans on unsealing them, and how she plans on having that process build. Because there are a lot of documents, right? A ton of documents. So I think that the plan that she has is a good plan. Obviously, all of this red tape is a bunch of BS. But at the end of the day, like I always say, everybody's entitled to the same rules under the law. At least that's the way it should be. And if the law allows for this to be the case, well, then the defendant, which is Ghislaine Maxwell in this case, has every right to try and go down these roads. It's up to the prosecution to make sure that she is cut off at the knees every time she hits an intersection. And so far, so good for the prosecution in the criminal case, right? And in the civil case, Preska has done a very good job here. And I expect her to continue to release these documents. Now, again, I'm not sure when it's going to happen, but in my opinion, we will see a majority of these documents released, but there will be some of them that will not see the light of day. So make sure you're prepared for that. We talk about it all the time here about how when you're dealing with the federal court system and you're dealing with the federal government, it's a long process, right? And you're in a federal case like this, and you have high-profile lawyers, well, they're going to get a couple of victories along the way. There is zero doubt about it. So just be prepared for that and, understand that this is going to be a very long process. There are still many ups and downs left on this roller coaster ride, but I think that things are moving in the right direction, and I think that the house of cards will most certainly be tumbling down the second we see the next arrest. All right, everybody, if you'd like to contact me, you could do that at bobbycapucci@protonmail.com. That's BOBBYCAPUCCI@protonmail.com. You can also find me on Twitter at BOBBY_CAPUCCI. All of the links that go with this episode can be found in the description box. All right, folks, we'll be back tomorrow morning. Hope everybody has a great night.